A New York man will spend decades behind bars for the brutal killing of his pregnant wife and the stabbing of their two daughters. Drew Garnier was sentenced to 30 years in prison, followed by 15 years of supervised release. But what's even more disturbing is what family members say motivated the crime. In court, Garnier's father-in-law said that the 33-year-old killed his wife because she was pregnant with their third daughter, and he wanted a boy. I'm your host, Kennedi Walker, and you're watching Law&Crime. Drew Garnier and his wife Samantha were raising their two daughters. The couple was expecting their third child. Samantha recently learned she was having another girl, the couple's third daughter. But according to her family, Drew was not happy. At 5 months pregnant and only 2 weeks away from celebrating her 30th birthday, Samantha was stabbed to death.
Samantha Garnier was located inside the residence and was rendered aid by responding patrols prior to emergency medical services arriving. Samantha was then airlifted to Wilson Medical Center, where sadly she succumbed to her injuries.
Police had responded to a domestic disturbance around 11:30 p.m. Inside the home, they found Samantha along with the couple's 6- and 9-year-old daughters, both of whom had been stabbed but survived.
Both children received medical care at Upstate Medical Center in Syracuse and are expected to make a full recovery.
Drew surrendered to officers at the scene. He was treated for superficial wounds and taken into custody. He later pleaded guilty to first-degree manslaughter and 2 counts of first-degree assault. A judge sentenced him to 30 years in prison, followed by 15 years of supervised release. The Delaware County District Attorney's Office said the trauma endured by the children was part of the reason prosecutors accepted a plea deal, one that spared the girls from testifying, but also resulted in a lighter sentence for Garnier. At Garnier's sentencing hearing, Samantha's father addressed a possible motive for the murder of his daughter. According to WBMG, he told the court Drew wanted a boy. He said Drew was upset to learn the couple's third child would be a girl and that his 2 surviving daughters are traumatized. Garnier asked for permission to contact the children he admitted to stabbing while serving his prison sentence, but the Delaware County District Attorney strongly objected, requesting no contact orders. The judge agreed, issuing an order blocking Garnier from contacting his daughters until 2056, though the order allows the girls to petition the court to lift that restriction in the future if they choose to. And joining me to talk more about this is trial attorney Aaliyah Roberts. Aaliyah, thank you so much for coming on today.
Thank you for having me, Kennedy.
So let's just jump right in. Such a sad story. We know this plea deal spared the daughters from having to testify, but what kind of trade-offs are prosecutors making when they accept a deal like this one?
Well, this is one of those deals that you have to give your tips off to the defense counsel because it was essentially unheard of, right? So simply the fact that he murdered his Samantha, I believe her name was, in cold blood, 29 years old, 5 months pregnant, that count alone should have been first-degree murder, and that sentence should have been life without the possibility of parole. As far as the daughters' 2 sentences, they're each sentence for the 2 daughters that were stabbed should have been anywhere between 2 to 25 years per child, right? So on top of the life without the possibility of parole, if the judge wanted to really, bang the hammer, so to speak, this defendant should have received anywhere between 2 to 25 years on top of the life without the possibility of parole sentence for each daughter.
Yeah. You make a really good point there, because a lot of people hear manslaughter and see a 30-year sentence and wonder, did the DA lose leverage here, or was this the best possible outcome under the circumstances? Can you explain that?
Sure. Again, everything comes down to strategy. I'd be very curious to see what type of evidence the DA had to go forth with trial, because sometimes if a lot of your evidence is circumstantial and you don't have direct evidence and you're hinging your case off of the testimony, that might have been a reason as to why he was a little bit more lenient. It is possible that they might have considered the fact that the defendant this was his first charge, or if he had never committed a criminal act before. I was also wondering whether or not the defense counsel planned to plead insanity as a defense, although in the state of Delaware, you have to actually have some sort of At the time of the specific crime, the defendant would have had to know that what he was doing, he wouldn't been able to know what he was doing was wrong based off of a mental illness. So depending on whether or not they could have pled temporary insanity or anything like that, or the defense was arguing that that was what his defense was going to be at trial, maybe that had to do with leverage. But like all things, it sounds really sad, especially when we're talking about loss of life, but it's a negotiation, right? So I'm sure that this was not, the first plea deal that was offered, but this is essentially what was the final deal.
We've all heard that wrinkle creams are the secret to looking younger, but according to one Beverly Hills doctor, that might not be the whole story. Dr. John Lake, a renowned cosmetic surgeon and beauty expert, says that most wrinkle solutions on the market are just glorified moisturizers, and they don't always deliver the results they promise. In fact, some can even irritate your skin, but Dr. Lake did not stop there. He's been working on something new, an anti-aging breakthrough he calls the Age Renewer method. It's a simple at-home technique that he says can visibly reduce the signs of aging in under 2 minutes. Think of it like a mini makeover, almost like Photoshop for your face, but real. Curious? Well, Dr. Lake put together a short video showing you exactly how it works, step by step, so you can try it yourself from home. He says if this helps even one person feel more confident in their skin, it's worth it. The response is huge. The video's already gotten over 2.3 million views, and the reviews are pouring in. Thousands of women say they look noticeably younger. One even said, "Best results I've ever seen. I'll never stop using this." If you want to see what it's all about, just go to bhmd1.com/law or click the link in the description below. Again, that's bhmd1.com/law. If you've tried other products without much luck, this could be the one that finally works for you. It only takes a few minutes to watch, so make sure you check it out right now by going to bhmd1.com/law. That's bhmd1.com/law. So most likely, do you think that maybe if things were circumstantial, they most likely needed to rely on witness testimony, which in this case would have been the two young children? So do you think maybe to avoid that, to avoid them testifying against their dad or reliving such a horrible experience, that's how he, got away with a lesser charge?
I definitely think that that plays a role for sure. I also think that the fact that, again, the girls were young, you don't want to traumatize them. I noted that Samantha's father gave a victim impact statement at sentencing. So he, spoke to the fact that the defendant murdered his daughter because she was pregnant with a girl and he didn't want any more girls. He wanted a boy. So it just seems that based off of the articles that I've been reading, and again, I'm not in the courtroom, right? Unfortunately, I don't have access to those things, but it just seems that there was a lot of reliance on the little girl's testimony. It seemed like that's how the prosecution was planning on making their case.
Yeah, the family, which I thought was so bizarre, just, reading this story and hearing about it when the dad gave his victim impact statement saying that, hey, he was upset, the wife was pregnant, he wanted a boy, this would have been their third daughter, which any baby is a blessing, but in this case, allegedly this is what happened. Could a motive like that be considered an aggravating factor in sentencing, even if it's not charged formally?
For sure, and it should have been, right? Like I said, the murder charge alone should have been life without the possibility of parole. If that went to trial, that's what the prosecution would have been asking for. So essentially, it's the decision that he ended up getting 30 years and then also parole. He only serves 80% or 2/3 of that sentence before he's eligible for parole. So the defendant might not even serve all 30 years. So he essentially is, I think he's in his 40s, I believe, or in the late 30s. So he'll have the chance to live a life. Even though he'll be older, he'll be able to live a life. And that is unfair considering the trauma that he caused not only his daughters, but to the family, his in-laws, and to his wife who he murdered.
Right. I think he's actually 33 years old, so younger than we think. So yeah, he'll definitely be able to have a life. Do you think that when parole time comes around that he could just get denied, especially if the grandfather speaks again, during his parole hearing, maybe even the children?
For sure. And I think having the children write their own victim impact statements will be very, very, very important to him not being released, especially because they'll be a lot older and the trauma of this experience would have really set in, right? They're younger now. And I know we say kids are resilient, but anytime you witness a horrible, horrible event like this and experience it yourself, right? Like you have to grow up knowing my dad tried to kill me and my sister and killed my mom, and having that impact before a panel that's considering releasing this person will definitely make a difference if and when he is eligible for parole.
Samantha was 5 months pregnant at the time. Is there any legal precedent for treating the unborn child as a separate victim in New York?
In New York, I'm not 100% certain. It just depends by state, right? Sometimes they'll add a certain aggravation based off the fact the person is pregnant, but seeing that child at 5 months, we have the argument of what point is life, right? Is life at conception, or is life after a certain point where they can breathe, or is life after, they're in the last trimester? It all depends on what the definition of what life is, right? As far as an unborn child is concerned. But I think 5 months, we're almost into the second trimester. I'm sure there are arguments that could be made that this child was alive and living, had a heartbeat, right? And should have their own specific charges based off of the incident in which my mother, the unborn child lost their life and the woman carrying the child lost their life. Unfortunately, as I said before, this sentence does not reflect that to me. This 30-year sentence and 15 years with 15 years probation does not remotely say that they considered this child as a living, this unborn child as a human being for purposes of sentencing. I'd also be curious to know, unfortunately, when it comes to probation, a lot of criminals reoffend during that time. So if he ever gets out, there might be a possibility that he reoffends and then is put back in jail. But, we'll only see
Right.
after extended period of time, right?
Right. And we know that the defendant asked for contact with his daughters that he allegedly stabbed, which stunned a lot of people. From a legal perspective, how common is that kind of request?
I mean, unfortunately, despite the fact that, he tried to murder his children, he is their parent, and parents do have rights. Parents do have rights to see their children. Parents do have rights to visitation, even in a situation such as this. Usually what will happen is the guardian, who I'm assuming is probably Samantha's parents or her family, will advocate for that child. But sometimes it could be a very, very sticky situation where the father would argue that the parents are biased and the children need their own attorney. And that attorney will speak to the children directly and ask the children, do you want contact with your father? Do you want to talk to him? And then it becomes a best interest of the child argument, and it will be a family court issue where his lawyer, the guardian's lawyer, and then the children's lawyer will all come together and argue whether or not the father is entitled to visitation or contact with their children.
Yeah, that's pretty mind-boggling if you think about it, though, for a man that was just convicted of
Absolutely.
murdering, his wife, the mother of the children, plus stabbing the other two daughters. So just wanting to
Mhm.
contact his kids are a little wild. But yeah, the daughters, they are safe with Samantha's father. The
Mhm.
court blocked all contact until 2056, but made it petitionable by the girls. Why
Mhm.
include a clause like that at all?
Because children are entitled to a relationship with their parents, despite the fact that their parents are murderers, despite the fact that it's very clear, based off of the fact that their father tried to kill them, right? He stabbed them, and the injuries were very, very serious, that you did not want me as a child, right? You wanted me to be a boy. But through therapy and through long term, the court wants to leave the door open if the children decide that they want to speak to their father. Even something as simple as, I can't believe you did this, you're a horrible human being, I never want anything to do with you, for the relief that they might have and might receive from having those conversations. And the children have the right to ask the court, hey, I want to speak to my dad, but not the other way around, because again, he tried to kill them.
Well, he reportedly refused to sign the no contact order. Does his refusal have any impact on its enforceability?
That's a great question. On its face, I'd say no, based off of the situation, because again, attempted to murder your children. So under the circumstances, I would argue that there's an emergency, circumstance in which your parental rights are temporarily suspended based off of the fact that you committed the most heinous act that you can as a parent against a child, right? But as I said before, he is still their parent, and a parent's right to parent is a fundamental right under the Constitution. So there's only but so much that the court can order. But based off of this specific situation, it's the best interest of the child, and to protect the child, his signature on that order does not make a difference, and it shouldn't make a difference.
Do children in cases like this one automatically receive long-term protections, or does the family have to advocate for those services?
It all depends on the judge and the circumstances of the case, right? I'd use an example of, let's say, instead of trying to murder the two girls, the defendant only tried to murder Samantha and the unborn child, right? Under that specific scenario, there's an argument that there was no exposure to violence or domestic violence to the children because they weren't present. So he should still have right to visitation under extreme supervision, right? Monitored, under extreme supervision. But because the children were not only exposed to domestic violence, they were themselves victims of domestic violence. It's the ultimate level of parental neglect. And arguably, based off of that, the guardians for the children should seek some sort of injunction to terminate the parental rights of the defendant based off of the fact that he tried to murder the two girls.
Absolutely. And those two girls, we can imagine, are going to be needing some type of psychological help for a
For
very
sure.
long time.
Mhm.
What do you suggest, or what kind of legal or emotional support can these girls expect as they grow up? How is that typically handled in the court system?
I think the court cannot mandate that the children go to therapy, even though it can be strongly suggested, especially if we're talking about, young girls who are going to be growing up, and not only just who have grown up, right? The sentencing was this year, but the murder was last year. So they've had a whole year, and hopefully they've been in therapy thus far, right? Or have had some sort of exposure. I think that if we see a circumstance which the children, let's say they come back in the court for some sort of petty crime or something like that, then they could have mandated therapy in lieu of their history and their situation, because it's probably more likely than not that the children committed whatever that petty crime was because of all the turmoil and all of the trauma they experienced with this situation. Like I said, I think it depends on how the court is set up. If the actual children have their own lawyer in family court, the lawyer themselves might advocate for the court to order that the children go to therapy based off of their separate conversations with their clients. Or the guardian ad litem might request that the guardian for the children might request that the court order therapy, but it's not something that the court would automatically order just because of the situation.
Right, right. Well, I guess, just again, this is such a terrible and horrible
Yeah.
situation to just wrap your mind around. But could the DA have pushed for a no plea policy in this case? And would that have been sustainable in court?
They could have, based off of the criminal code that says that this specific crime should have been life without the possibility of parole. I think that, as I said, because it seems that the DA might have believed their case was not strong enough, or wanted to spare were heavily relying on the daughter's testimony, because it's the only way that makes sense as to why they would give such a lenient sentence based off of this, right? So it arguably in trial, because they would ask for life without the possibility of parole if they went to trial. I can imagine that in the negotiations between the defendant's lawyer and the DA, that there were conversations about not having parole at all and not ever being released. But again, that's why it's called a plea deal, right? Because it's a deal on behalf of the defendant, and it saves the court money from a trial, and also saves the family the trauma, not just the daughters, but also Samantha's family, right? Her father having to get up there and testify as to his experience with the defendant and his experience in losing his child. So all of that to be considered, I think that, the DA I say it was a get out of jail free card. I think that the sentence was extraordinarily low based off of all of the facts and circumstances. But again, that's why it's called plea bargaining or a plea deal.
Do you do you think that A plea deal like this one sends a message, especially in cases involving domestic violence and child victims?
Absolutely. Absolutely. Especially in the state of Delaware, right? We recognize that this incident happened in Delaware, even though the defendant was a New Yorker, right? But I
Well, yeah, can
also
you
think
explain that as well? Because I know that's kind of confusing. Because it's upstate New York, but is it technically like the border? Some consider it upstate New York, some consider it
so.
Delaware.
Yeah. It depends on the. I think if I'm not mistaken, I know it says that the incident happened in Delaware. In the event that the trial itself occurred in upstate New York, then the state of New York's sentencing guidelines are the guidelines that are to be followed. It was and I could be mistaken, but I thought that the court it occurred in the state of Delaware. So as far as Delaware state law is concerned, Delaware state law requires first degree murder to be life without possibility of parole. Right? New York states are a little different. And again, New York has a lot of crime, right? And a lot of, it's a huge, you have New York City and then you have the surrounding areas. So you have a higher volume of cases that come in and out of New York State. So because of that, it is encouraged for deals and bargains to be made. But I also feel like it's unfair to give a sentence that is so light considering the severity of not just Samantha and her unborn child, but these two little girls.
Right. Well, again, crazy story here, and we will definitely be thinking of those little girls and hope that they have a good life moving forward. Aaliyah, thank you so much for coming on today.
Thank you, Kennedy. Always a pleasure.
A GoFundMe was created to help with expenses for the two young girls. Both girls were adopted by their grandfather. For Law and Crime, I'm Kennedi Walker.